Hi, my name's Chris Sinal. I'm a partner in Siskinds Management Side Labor and Employment Group. That essentially means that our practice is just based on helping our employer clients manage and control the costs related to all of their obligations stemming from their employment relationship with all of their workers. Now, a big part of my practice is managing costs related to WSIB and occupational health and safety claims. So what I want to spend a few minutes today is just talking about the various ways that we help our clients do that and that you can think about as employers. When it comes to WSIB, there are three main ways that we can control those costs. The first one is, if there is a workplace injury, managing that return to work process in the most efficient way possible. WSIB is going to help you do that through the return to work specialists, ideally. But one of the big things from that is we have an interest in making sure that those people can get back to their full wages as quickly as possible, because any loss of earnings benefits that accompany an injury and try and cover that delta between what they're actually being paid and what their original wage rate was is going to get applied to the employer's claim costs and can have the effect of raising premiums. Convenient thing about this is, of course, employers have obligations under the Human Rights Code to accommodate employees, and the overlap of the WSIB obligations and the human rights obligations is often close to a circle on that Venn diagram. So when we try and manage our responsibilities in one area, we're often covering off our responsibilities in the second. The second big way to try and manage those claims costs is to ensure that our premium rates, which are all related to what I'm going to call classifications. The WSIB changed a lot of its terminology a couple of years ago, but making sure that those premium rates are accurate and that we're actually in the proper classification that we should be based on our business activities. That usually involves an assessment of when were your last WSIB audits, looking at some of your claims documentation, and really considering what is the proper code that you should be in. If we discover that, in fact, there's an argument you're in the wrong code, there can be substantial claims savings going back 1 to 2 years, depending on the circumstances. So always something to look at. The last big area we focus on within the WSIB context is actually just making sure that the WSIB's decisions are correct. That could be whether entitlement is even owed under the terms and conditions of the plan anyway, or if the WSIB is assisting in managing a claim, that they're managing it appropriately. Now, as an employer, you're going to get copies of any decision that the WSIB makes. And oftentimes there will be a boilerplate section just at the bottom of those decisions that says that you have the opportunity to object. Most of those objections have to be raised within 6 months of the decision being made. Some are a lot quicker though. So we usually recommend reaching out to counsel to make sure whether it's worthwhile appealing this or not. Our answer tends to be it's worthwhile at least filing what's called a notice of intent to object. That's just a signal to the board that, you know what, you just want a second set of eyes going on this claim. And once that happens, normally you'll be given access to the employee's claim file. Now listen, you can only use the medical information and other information in that file for the purposes of adjudicating that WSIB claim and determining whether it's appropriate. But my advice, although this isn't actually legal advice, just to be clear, it's probably a chyron on the bottom that says that. But anyway, just to be clear, I always recommend that clients file that initial intent to object so that they can have a look at the claim file and see, was this decision made appropriately and correctly, or is there something that we should potentially consider taking down the road for an appeal? Just because you filed the intent to object doesn't mean you need to appeal and incur those costs. But I'd rather you have the information to be able to make an educated decision on what are the costs of appealing versus not appealing and what are the various risks. Those are the main areas that we tend to look at on the WSIB matters. The second area for employers when it comes to health and safety is their obligations under the Occupational Health and Safety Act. I doubt this is news for everyone. There are different rules and regulations under the Occupational Health and Safety Act depending on the nature of the industry that the employer is in. Some, like construction and industrial environments, have very specific rules. The three big things that I suggest clients focus on is one, properly training their employees and having that training information and documentation on file. It's one thing to have invested the time and energy in getting a boilerplate set of policies. That is absolutely better than nothing. But if we have bespoke policies for the type of work that we're doing, that is vitally important. But more important is actually making sure that we have the systems in place to train our supervisors and our employees to do them effectively. If there's a workplace accident and the employee says, I just learned how to do X because the other people on the line showed me, that is not something that's going to form the basis of a valid defense under the Occupational Health and Safety Act. So training is the most important thing. Costs invested in that can go miles and miles when it comes to potentially defending in the event of an accident. The second thing is documenting the fact that that training has happened and those policies exist. Litigation and defense of occupational health and safety charges is a document-intensive affair, and we want to make sure we have as much evidence as possible that the training has happened, who attended, etc. So document everything that you can. And the last thing is having a concrete plan in place in case an accident happens. How are you going to respond? What are you going to do in the event of an accident or near miss? Knowing when are your mandatory reporting obligations to the Ministry of Labor, and figuring out who is going to be in charge of controlling that flow of information and making that report. That is vitally important because those initial reactions after the workplace incident, making sure that we comply with our obligations under the legislation and controlling exactly what information is given to the Ministry of Labor, can be extremely important in the event of charges. If an accident happens, it can be up to 2 years before the government decides whether to do those charges. And the fines can be significant, anywhere from $40,000 to $50,000 to $60,000, depending on the nature of the injury and the fine, all the way up to hundreds of thousands of dollars in the case of a fatality. And so what we want to make sure is if charges do come in, you're in the best position possible to defend those charges and, again, make an assessment of what are the risks of proceeding through litigation or potentially negotiating a resolution from the Crown to come up with the best possible outcome for the business. And in order to make that educated guess, we want to make sure we have all of the documentation and facts available to be able to properly advise you. Those are the main tips, 3 on each of WSIB and Occupational Health and Safety, to reduce and control the costs associated with those areas. There's a variety of other things that we advise our clients on. I have a large number of unionized clients that can be collective bargaining, grievance arbitration, as you can imagine, human rights. Our management side labor and employment group advises on the full gamut. And if you have any questions of what we can do to help you manage those aspects of your business, please don't hesitate to contact us.